over the next 2 hours, you will increase your knowledge about post-grant proceedings before the U.S. Patent and Trademark Office as a way to challenge patent validity in the U.S. as an alternate to standard litigation. I believe this slide covers most of what Ben just introduced me with. It's my background slide. I have an education in electrical and computer engineering. I have a law degree from the University of New Hampshire School of Law, which is where your host, Ben Quang, and I originally met. I have a 25-year career at the Patent Office in a variety of positions, and I have now a 10-year career outside of the PTO, including litigation as well as patent prosecution. I am currently a partner at Resolute Legal, which is a small boutique intellectual property focused law firm in Northern Virginia. And I am currently adjunct faculty for the University of New Hampshire. So today, I'm going to talk to you about challenging patent validity in the United States. We're going to discuss the America's Invents Act and the post-grant proceedings that this law created. We're going to take a look at the Supreme Court review of these proceedings and how the laws have changed over the 9 years that these proceedings have existed. We're going to take a look at trial statistics and costs for these proceedings. We're also going to take a look at re-examination proceedings as a less expensive alternative to these litigations. We're going to compare these proceedings, and then I'm going to conclude by offering some practice tips for patent owners, as well as some practice tips for patent challengers. In the United States, there are a variety of paths with which someone may bring a challenge to the validity of a patent. Now, the first question is, why do you want to do this? And most often the answer is, the patent has been asserted against you. Someone, a patent owner, accuses and brings a suit for infringement against a patent claim. And in defense, there is a counterclaim that that patent is invalid. So most challengers are accused of infringing a patent, and they desire to remove that patent and remove that impediment to their business. There's federal court review in the United States, and that's going to be the subject of a future lecture by my business partner, Dan Ho. You're going to hear from him in a couple of days about the federal court litigation practices, as well as the International Trade Commission practices in the United States to stop importation of articles that allegedly infringe a U.S. patent. Today, we're going to talk simply about the administrative review options, also known as patent office litigation. These proceedings are conducted before the Patent Trial and Appeal Board of the USPTO or in front of examiners before the USPTO. And the proceedings are known as inter partes review, which I refer to as IPR, or post-grant review, which I refer to as PGR. or ex parte re-examination proceedings. In 2011, the United States passed the America's Invents Act, which we refer to in the US as the AIA. And this was a sweeping change to patent law in the US. It fundamentally changed our patent examination system from a first to invent system into a first inventor to file system. It changed our definitions of prior art. It changed our requirements for applicants, and it created new trials, new proceedings with which someone could challenge the validity of the patent before the office. It also, in addition to the IPRs and the PGRs that I have mentioned, it also created a similar covered business method proceeding called a CBM. The CBMs were limited to an 8-year existence in the AIA, and that term has expired. So while there may be some covered business method review proceedings that are still under court review, the Patent Trial and Appeal Board is no longer accepting petitions for that type of proceeding. It has lived its life and was not extended. So there are no more CBMs, and I'm not going to discuss those. The AIA also created derivation proceedings. The derivation proceedings are not directly related to patent validity, although patentability may be explored within that proceeding. Derivation proceedings involve patents or applications where there is a dispute as to whether or not the first inventor has actually been the first to file. So that's not going to be a subject of our talk today either. This change in the law, the AIA, renamed the existing Board of Patent Appeals and Interferences and called them the Patent Trial and Appeal Board. Now, previously, the Board of Patent Appeals and Interferences reviewed unfavorable examination decisions from examiners and conducted interference trials to determine inventorship. The PTAB continues in its role as reviewing unfavorable examination decisions, and it currently additionally conducts all of the new AIA trial proceedings, and currently that's IPRs, PGRs, and derivations. The Patent Trial and Appeal Board is a different audience than that of the federal U.S. court judge or citizen jury. The PTAB judges are technically trained and legally trained. They all have science and engineering backgrounds and expertise, and they are all practicing lawyers. Most have prior IP experience, including there are many former examiners that now serve as PTAB judges, and they have a balance of prior patent prosecutors and prior patent litigators within their ranks. So they have a variety of background and experiences and are familiar with the entire life cycle of a patent as well as its business implications. In this slide, I have a graphic that just shows the interaction between the filing of a patent application, how it's examined by the examining court. It may issue into a patent, and that patent and its patent validity may be reconsidered again by the examining court through an ex parte re-exam proceeding, or it may be considered by the Patent Trial and Appeal Board through a post-grant review and an inter partes review. The congressional record of the statute makes clear that the AIA trials were implemented to ensure a just, speedy, and inexpensive resolution to patent disputes by providing an alternative, cost-effective procedure to adjudicate patent invalidity. At the time the AIA was passed, patent litigation was rampant in the United States and very expensive for business owners. And the congressional intent was to provide an alternative path to resolve patent disputes. What has happened, however, is in many instances, these proceedings have become a strategic tool, a business weapon, licensing and negotiations tactic, and have resulted in an additional parallel proceeding to the district court litigation. So instead of reducing costs, they seem to have added costs for many patent owners. They also seem to have added costs for many patent challengers. They are less expensive than district court litigation when compared as an alternative, but as an addition, it is more expensive. And there's great debate about the justness of the PTAB judges. We'll cover that a bit more in the future. What can be said for sure is that these proceedings are fast. They are concluded within 18 months total, and the trial itself lasts 1 year or less. So they are faster than district court proceedings. There are very high success rates for the validity challenges. We will look at some statistics later on and speak to this. But because they are successful at invalidating patent claims, they have become a sword for clearing through patent landscapes. Many, many, many of these proceedings have been filed, and many claims have been invalidated by PTAB judges. In the beginning, there was much uncertainty about these proceedings. The AIA gave the USPTO 1 year to create and implement these new administrative trials. The PTAB quickly began hiring judges and creating new rules for how to conduct these new trials. They drew from the prior experiences that the office had in conducting other administrative trials, in particular interference proceedings and inter-party re-examinations, which were abolished by the AIA. So the PTAB looked to the paper-based, motions-based trial proceeding model and considered the positive and negative aspects of a prior inter-parties dispute proceeding to create the rules for the new proceeding. In these new proceedings, expert testimony is extensively used, and it is taken via declaration to support a petition, and to defend a patent, as well as depositions of those experts by both sides. Live testimony has occurred in these proceedings, but it is very rare and it is very difficult to get authorized by these judges. So they really are a paper-based proceeding. And the goal is to conclude the trial within 12 months of institution. That is by the statute. And to date, they have met that goal in the way that they have defined the proceedings. They have met that 12-month goal. So let's take a look at the timeline of the proceedings. They begin when a petition for review is filed, and that starts a 3-month window for the patent owner to respond with a preliminary response. And if no more than 3 months from then, so 6 months total, the Patent Trial and Appeal Board will render a decision on institution of the trial. That means the petition meets the standard that it's asked to meet for trial institution, and that they're going to trial. And then there's discovery period for both sides. The patent owner gets to request discovery and depose the petitioner's experts. And then the petitioner has 3 months to have discovery, at limited discovery, and to depose the patent owner's experts. Both sides get to make replies after those experts are heard, and an oral hearing date is set. An oral hearing is conducted, and then the PTAB judges render what is known as an FWD, or a final written decision. And once that final written decision is entered, the proceeding can then proceed to court appeal through the Court of Appeals, through the Federal Circuit, and ultimately to the Supreme Court, possibly, like any other PTAB final decision. So the trial phase, with the depositions and the discovery periods and the supplemental replies, also can include motions by the patent owner to amend the patent claims. Now, this practice is also very difficult to execute, but there is a path for a patent owner to amend his patent claims, to narrow his patent claims. And this time period is also available for negotiation of settlement. And if the parties agree to settle, they can jointly petition the PTAB to close the proceeding without issuing that final written decision. Settlement is very much encouraged by the PTAB. Again, they are looking for a just, speedy, and inexpensive resolution for all of the parties, and so they are generally quite favorable to settlements. The terms of those settlements can also be kept from public disclosure. So you can have private settlements. You will have to show it to the judge, but it can be kept out of the public record. And all of this occurs within 12 months, which is much faster than similar outcomes and results in our federal court system. When the trials first began, there was a great deal of uncertainty. I was practicing in this space in 2012 and assisted with the drafting of some of the very first petitions that were filed. This was because I had a unique combination of experience from inside the office, having been the manager of the prior unit that handled inter-parties reexaminations, as well as having been an interference practice specialist. So I was also familiar with interference trials. So when we started drafting these new petitions under the rules that were drafted and published, there were many, many outstanding questions as to not only how these proceedings were going to occur, but what were the meanings of the language in the rules and what were the meanings of the language in the statute that created the proceedings. So there were many questions, many issues, many points of contention, and almost every initial proceeding, regardless of outcome, patent claims were affirmed, patent claims were held unpatentable. It did not matter. Almost everything had open questions, and these proceedings all went to the Court of Appeals for the Federal Circuit to start weighing these issues and rendering guidance back both to the PTAB judges and to the patent owners and patent petitioners. Over time, many of these legal decisions from the CAFC were petitioned to our Supreme Court, and the Supreme Court has rendered several decisions related to these AIA proceedings. The Patent Trial and Appeal Board has also, over time, amended the rules to help strike the balance of fairness and to implement the clarity provided by the courts on certain issues. So next, we're going to take a look at some of these Supreme Court decisions. Immediately, patent owners have fought for their property rights. The first couple of years, these proceedings, almost every single one that was requested was granted to trial. And approximately 85% of their trials resulted in patent claim cancellation. So the Patent Trial and Appeal Board quickly gained a reputation and was called by a former chief judge of the Federal Circuit. Chief Judge Randall Rader called the PTAB judges the death squad for patents because they were finding so many patent claims invalid in these proceedings. So patent owners, fighting hard for their property rights, began challenging the constitutionality of the trials as a whole, in addition to challenging the findings within the proceeding. So the first constitutional challenge that made it to the Supreme Court in the US is a case known as Oil States Energy Services, or Oil States as a shorthand. Oil States considered whether the proceedings themselves, and in particular inter-parties reviews, violated the US Constitution by extinguishing a private property right without an Article 3 judge, which is the US general court system, and without a jury. Our Constitution has a clause that there will be no unreasonable seizure of private property by the government. So this was the underlying issue that was being challenged here. The patent right was framed as a private property, and it was being allegedly improperly removed by the government. The court, in resolving this issue, distinguished public rights and private rights and reframed the view that a patent was a private right to bear in mind that a patent was also the grant of a public franchise, the grant of something that, to a member of the public for a limited period of time. And on that legal distinction, the court concluded that these proceedings were constitutional. In other words, the Supreme Court decided that what the government grants, the government can remove. This was not an impermissible government taking. So that was a disappointment to patent owners, because they were, of course, fighting for their property rights. More recently, as in a couple of months ago, I believe it was June of this year, another constitutional challenge was heard and decided by the United States Supreme Court. And this case, US v. Arthrex, which is also referred to as Arthrex, argued that the PTAB wielded the government powers of a principal officer, which should have been appointed by the president and with the consent of Congress, but they were hired as inferior officers. They were appointed by the director, the Department of Commerce head. So the argument was that all of the judges were inappropriately appointed, that the AIA gave them powers that exceeded their formal appointment. And because of that, because the judges were unconstitutional, all of their actions were unconstitutional. This case sought to unravel the entire scheme of post-grant review and to reverse all of the decisions that have been occurring over the past 8 years. And the court, the issue was one of administrative law, not one of patent law. And the court ultimately held that the judges do act as principal authors. But this is because they have unreviewable authority. And rather than deconstruct the entire proceedings that have gone on, the court decided the solution was that the decisions of these judges must be subject to review by the director of the USPTO. And they noted that the director need not review every decision, but that the director should have the discretion to review these decisions. And so immediately the Patent Office released guidance on how, after a final written decision is rendered, a dissatisfied party may request director review of the proceedings. And so this change in internal policy in the Patent Office is a result of this decision and rectifies the problem with the appointments clause under administrative law in the United States. So once again, patent owners failed to establish that these proceedings were unconstitutional, and they continue. There are, as an aside, there are additional constitutional challenges working their way through the courts right now. So patent owners are still pursuing lines of legal reasoning here to stop the death squad of patent claims, so to speak. The first decision that the Supreme Court took up is known as Cuso Speed Technology, or Cuso, questioned whether the PTAB was using the right claim construction standard in reviewing patent claim validity. Initially, the PTAB chose to use the broadest reasonable interpretation for claim construction. In contrast, in district courts, the standard for claim construction is ordinary and custom meeting, set by the Phillips decision. And there's a slight difference between these two standards. Broadest reasonable interpretation is the standard used by examiners when examining a patent application, and it is the standard used by examiners in re-examination proceedings. And it seemed reasonable to the Patent Trial and Appeal Board that that should be the standard that they were using, because before the Patent and Trial and Appeal Board, these proceedings, the patents do not hold the presumption of validity that they hold in a district court proceeding. So Cuso challenged this claim construction standard, and the court held that the Patent Trial and Appeal Board and the USPTO had the right to pick the claim construction standard, and that the broadest reasonable standard was not incorrect. However, based upon public pressure and public comment, 6 years later, after Cuso was decided, the office on its own amended the patent trial rules and switched to the broader Phillips standard. So currently, the claim construction standard before the Patent Trial and Appeal Board is the same as the claim construction standard utilized in district courts. Cuso also held that the Patent Trial and Appeal Board's decision to institute that decision at the first 6 months, whether or not the trial should occur or not, is not appealable. These post-grant proceedings are time barred. They must be brought, these challenges in these proceedings must be brought by a challenger within 1 year of being accused of infringing a patent claim. And so the issue here was, if the petition is filed very close to that 1 year point, and there is a fault in the petition that results in the trial not being granted, can the petitioner appeal that decision and try to get the trial granted? This occurred because there was not enough time to file another petition. The time limit had expired. And the Supreme Court held, no, the law is clear. The PTAB has the discretion to decide whether or not the petition is sufficient to warrant a trial, and that decision is not reviewable when that decision is based upon the facts of the record. However, if the challenge to the denial of the petition is based upon constitutional questions, it may be reviewable. So there's a slight window of hope there, depending on what the issue is. However, to date, I'm not aware of anyone who has challenged that successfully on other issues other than the merits of the petition. So as you can see, with these initial Supreme Court decisions, we are starting to get some clarity into these proceedings and how they should run. The next important Supreme Court decision about post-grant proceedings came to us from SAS Institute. Initially, the PTAB utilized judicial discretion to partially institute trials. And that is to say, a petitioner may have requested a trial to hear the patentability of claims 1 through 20 of a patent. And the judges may have decided that only claims 1, 4, and 10 were sufficiently supported to warrant trial. And so, to be efficient and speedy, they would only institute trial on 3 claims instead of the requested 20 claims. And this practice went on a great deal. In almost every decision, it seemed like the judges were deciding only to partially institute, only, less than all of the claims were being sent into trial, and that created a lot of questions about what happens to those other claims. What is their standing? What is their position in the patent at the conclusion of that trial? So SAS Institute appealed this decision, and it went all the way to the Supreme Court. In SAS, they requested a number of claims, and the Patent Office partially granted review and then invalidated all but one of the 9 claims under review. And on appeal, the Federal Circuit supported the Patent Office's actions. But the Supreme Courts, after they heard the case, said the clear language of the statute required them to decide the patentability of every claim challenged in the petition. That the statute uses the word every, and that means every. And so the practice of partial institution was stopped. Another important decision of note by our Supreme Court happened in Return Mail v. the U.S. Postal Service. In this situation, in this dispute, Return Mail, a private company, asserted a patent related to the handling of mail, asserted that the United States Postal Service was infringing their patent. And in response to that allegation, the Postal Service sought to implement an inter partes review of Return Mail's patent. And Return Mail argued that the United States Postal Service did not have standing under the AIA to institute a trial. Well, the PTAB disregarded that argument, granted the trial, and held all of the claims invalid. And the Court of Appeals for the Federal Circuit affirmed that decision. It went to the Supreme Court, and the Supreme Court held that the AIA required a person to apply to petition for a post-grant review, and that the federal government is not a person capable of requesting the post-grant review. So there can be no government challenges to patents. And this is, in my opinion, certainly the right outcome here, because it would get the logical conclusion of allowing the government to challenge the government on patents can get very confusing. So our laws don't prevent government agencies from obtaining patents, but our laws do prevent government agencies from requesting those patents be invalid. And a more recent decision in 2020, time-barred proceedings cannot be appealed. The situation here was similar to that in SAS. It was an issue where an appeal was brought, a trial was sought that was time-barred, and the holding basically was the idea that the board can properly institute an inter-parties review on some but not all of the challenged claims was distinguished from the manner in which the agency review proceeds once instituted. So the court here was distinguishing review of the petition and granting the trial on all claims does not mean that the trial actually proceeds on all claims. Just I brought this case to the slides to give you an idea of how fine a line the issues are being resolved with these proceedings, that patent owners are fighting in every way they possibly can to save their patent claims here. So, as you can see, these proceedings are powerful, and they are popular because they invalidate claims. So, in our next section, I'd like to take a look at some of the statistics around these trials to give you an idea of just how effective they have been. This is a pie chart graphic of petitions by trial type since they started in 2012 and through the end of January 2020. I was not able to locate 2021 statistics. And this shows overwhelmingly the majority of the types of trials that have been held have been inter-parties reviews. The covered business method proceedings, or the CBMs, which no longer exist, were the second most popular type of trial, and the post-grant review is a very small percentage of the proceedings to date. And I will cover the differences between the post-grant review and the inter-parties review in the next section of my talk. When you look at the rates of institution of trial instituted versus trial denied, this is a reflection on the effectiveness of the petition. You can see that early on in 2013, when the proceedings first began, there was a very high rate of trials being granted, 87%, and in 2014, 75%. Over time, the effectiveness of these petitions has decreased. And this is likely because we have more clarity on how to move forward on certain issues in petitions. And currently for fiscal year 20, according to this slide, that institution rate was down to 56%. When you think about here's the type, the same slide as my first one for trial type just for the current 3/4 of the current fiscal year at the USPTO. So far since October 2020 through March 2021, the first 6 months of the year, over 1,300 trials, petitions have been filed, and 91% are inter-parties review. The post-grant review filings are increasing, and we're 9% of the filings so far this year. When you take a snapshot of what technologies are being challenged through the inter-parties review, the majority are in the electrical and computer arts, followed by the mechanical and business method arts. Chemical arts and biopharma arts are tied at 6% each, and very, very few design patents have been challenged in this year and in all years. Design patents are eligible for post-grant challenges, but it's not being used a great deal in that area of patents. The institution rates, this is just showing the last couple of years on the petitions, seem to be increasing so far in fiscal year 21. I believe the increase in filings is due to the clarity that has been provided by the Supreme Court in the recent court decisions, and people are moving forward with filing new petitions. And again, the institution rates, just in a different graph by technology. These are all-time institution rates from September 2012 through January 2020. And this shows that over time, the electrical, the percentage of electrical and computer is lower than the percentage of mechanical and business method. And this slide is reflecting partially the prior CBM proceedings, which were generally considered business methods. And so over time, the electrical and computer bar graph there should increase and be the heaviest used area. Currently, this year, as you can see, computer does outpace mechanical. Note that the design bar there, it looks like the graph is saying there's a whole lot of design patent reviews occurring, but 75%, this chart is by percentage, not by sheer numbers. There have only been 4 inter-party reviews filed on design patents this year, and 3 of them have been granted. So that's a very high percentage of grant rate, but there's not very many of those types of petitions. Settlement rates. Settlement rates over the years have varied. Usually about 1/4 of the trials granted settle. Currently in this fiscal year, settlement is up. Looking for the first half of the fiscal year, it looks like about 1/3 of the petitions are going to settle this year, which is a little bit higher than it has been over the past 5 years. And this slide is very, very interesting and informative to patent challengers, because this is a look at outcomes by the number of claims challenged. And this is for fiscal year 21. So this is current data from October of last year through January of this year. This is showing what's going on currently with the rules and with the laws in the United States. And currently, 1/3, 30% of petitions are denied. 37% are granted, but are not resulting in a final written decision. This includes the purple slice, includes the settlement decisions. 8% of the trials that are granted result in a final written decision where the claims are held valid. Almost 20% result in a final written decision where the claims are held invalid. 5% of the trials that are granted, the patent claims are disclaimed, and again, rather than settlement, a disclaimer removes the need for trial. So when a patent owner disclaims the patent, those claims are no longer in existence and the trial disappears. And so a takeaway from this slide is these trials are effective for challengers to get claims amended or held invalid or disclaimed, or as 1/3 of the results show, these trials are effective at leading to a settlement agreeable to both parties, perhaps when settlement was not an option before. So, which proceeding would you seek? What is the difference between an inter partes review and a post-grant review? So, once the trial is instituted, the conduct of the trial is generally the same. The differences in these two proceedings reside in whether or not the patent is eligible for the proceeding, what grounds can be reviewed in the proceeding, when the proceeding must be filed, and what is the standard that must be met to have the trial granted. So an inter partes review is available to any patent, whereas a post-grant review is only available to patents that have an effective priority date on or after March 16th, 2013. So inter partes review for older patents, post-grant review and new, post-grant review only for newer patents. Inter partes review can only explore patentability under the novelty and obviousness statutes and can only be based on patents and printed publications. So there's limited grounds that can be reviewed in an inter partes review, whereas in a post-grant review, any ground can be asserted except failure to comply with a best mode requirement. This means clarity issues can be asserted under 35 USC 112. The claims and claim clarity can be explored. Patent eligibility under 35 USC 101 can be explored under a post-grant review. Prior public use can be explored under a post-grant review if the patent being challenged is eligible for that review. When the challenges must be filed. For an inter partes review, it must be on or after 9 months from the date of the patent issue, And for a post-grant review, a PGR, it must be no later than 9 months from patent issuance. So in order for a challenger to take advantage of a post-grant review, they have to be watching an art space or their competitors' patents being issued, and they must very quickly decide to attack the patent under a post-grant review and to prepare and file a petition. They must be filed within 9 months of the patent issuing. And part of the reason for creating post-grant review was to encourage this quicker attack on an improperly granted patent, to minimize the damage of that patent, to have industries start to self-police the patent space and bring these challenges quickly back to the patent office. And the institution standard for an inter-parties review is a reasonable likelihood that the petitioner would prevail with respect to at least one challenged claim, versus a post-grant review it's more likely than not that at least one claim in the petition is unpatentable. So there's not a lot of clarity about those two standards, other than it's generally viewed that more likely than not is just a little bit lower than reasonable likelihood. But at a broad level, that's the difference between these two types of proceedings and the petitions that you would bring. There are differences in the mechanics of the petitions themselves, given that post-grant review encompasses additional grounds for rejection, proposed rejection, and additional types of prior art. These petitions can be longer based in the rules versus the inter-parties reviews, which are limited in word count. The post-grant reviews have a larger word count. So there's some subtle differences in the mechanics of how these petitions work. But generally, fundamentally, this chart highlights the major differences between these two types of proceedings. Let's take a look at filing fees. Wow, they're both expensive. These are just in your filing fees to the office. To file an IPR petition and challenge up to 20 claims, it's $19,000 for the filing fee. And then, if the trial is instituted, the petitioner must pay an additional $22,500 to pay for the trial. And there are additional claim fees for each one of those situations that are listed there. And that is, if you're going to challenge 21 claims, you have to file an additional $375 to file the petition, and then an additional $750 for the trial. PGRs are a little bit more expensive. They generally encompass a little bit more work because they generally have additional questions of patentability, additional statutes of challenge, additional types of prior art. There's more issues and more work. So they are respectively more expensive than the IPRs. And the attorney costs for preparing and filing the petition versus the attorney trial costs through appeal, these numbers are pulled from the Intellectual Property Owners Association's annual survey of costs, and I pulled numbers from 2019 because that was the latest copy of that survey that I had on hand. The costs are lower now than when they initially started because so much has been learned about these proceedings, and and efficiencies have been gained in preparing petitions and in executing trials. The costs vary a lot based upon the number and quality of expert witnesses that are used in the trial. But generally, they also vary dependent upon the value of the stake of the alleged infringement of the patent and how much money is at stake for damages. So the more that is at stake, the higher the costs. But the filing of a petition can run from $40,000 up to in excess of $100,000, and the entire cost of the proceeding can vary from 300,000 up to, close to $1 million. And yet these costs are generally lower than district court litigation costs. So in the next part of my talk, I want to remind everyone about the existence of ex parte reexamination, which remains a viable option for a third party to challenge a patent claim. It's a little bit different in that it's not a trial. There's no inter partes reexamination anymore. It's just ex parte reexamination. Requests for reexamination of a patent may be filed by anyone. It may be filed by the patent owner himself. It may be filed by a third-party requester, including the director of the USPTO. There are director-ordered reexaminations. And it may even be filed by an anonymous requester. Whereas in the trial proceedings I've been discussing, the real party in interest of the petitioner must be named. In a reexamination, the requester may remain anonymous. The standard for granting a reexamination is a substantial new question of patentability. Now, this is more than just a new piece of prior art being uncovered. There must be an analysis done in the request for reexamination of the questions that were explored and resolved in the prosecution history of the patent, and why this new art or the old art, viewed in a new way, present a new question of patentability. And that standard is actually the new question. The SNQ standard boils down to, would a reasonable examiner consider this question important to deciding the patentability? So it's generally pretty easy to come up with a new question of patentability. The trick is to understand that aspect of the request for reexamination and to make sure you frame the question correctly. Many requesters just say, here is new prior art, therefore there is a new question of patentability. And the patent office generally will not grant that request. You have to address the question and why the art is not cumulative to the issues already decided. Once granted, third-party requester is out. You do not get to participate in the proceeding at all. It is between the patent owner and the patent examiner, and as a requester, you just get to watch what happens. The patent owner will enter a limited prosecution. And by limited, they can amend and they can add new claims. but they cannot broaden any claim in that proceeding. They can only narrow or further limit the claims. They may appeal the rejections entered by the examiner, but ultimately a reexamination certificate will be issued, and many times those claims are altered as a result of that reexamination. So I want to take a look at these reexamination statistics because it's important to this idea that the Patent Trial and Appeal Board is a death squad. Patent reexamination was established in 1981. So we have over 40 years of data about these reexamination proceedings. And these statistics are just showing the numbers and the percentages by technology of the filings in reexaminations over the years. And you can see that reexamination has consistently been utilized by patent owners and third-party requesters to effect changes to patent claims. And the numbers of percentages of the technologies where reexaminations are filed track very closely to the percentages of by technology of post-grant reviews before the PTAB over the last 10 years. So there's no real surprises there that electrical cases take up the majority of reexaminations, followed by mechanicals, followed by chemical bio, and the lowly design patent still having very few reexaminations requested and granted over the 40 years that this proceeding has existed. Importantly, however, when we look at the statistics about the claim outcomes for reexamination, we will see that over 40 years of reexamination of patents, when requested by the patent owner, 80% of the claims exit reexamination either narrowed or canceled. The same percent exit reexamination when that request is by the third party requester. And again, 90% exit reexamination canceled or amended, narrowed when the commissioner or director instituted the reexamination. I find it fascinating that the public calls the Patent Trial and Appeal Board a death squad to patents, when for 40 years, patent examiners and reexamination have resulted in the exact same or higher numbers of claims being amended and canceled. My personal take on this is that reexamination is viewed as being more fair to patent owner than the Patent Trial and Appeal Board proceedings. However, the results are the same. There's prior art has been uncovered that has altered 80% of the patent claims that go through reexamination. And that is a higher outcome over time than currently the PTAB proceedings are showing. Approximately 60% of the proceedings are coming out with canceled or amended claims. So reexamination is still a very viable and powerful way to challenge a patent claim. And let's look at the costs. Entity size, just like in patent examination, plays a role here, but even assuming a large entity, you can file a streamlined reexamination for $6,300, or a non-streamlined examination for $12,600. So the most expensive, most comprehensive re-examination is less than half the cost of an inter-parties review. And the attorney costs to prepare and file a re-examination here, it varies depending on how many substantial new questions, how much prior art, and how many claims, but it varies, and generally 15 to 80K are the numbers that I've seen. And it falls in range with my experience of what I've prepared as a patent attorney. So re-examination has much lower costs and similar claim canceling outcomes. The budget-conscious petitioner should consider this as a viable opportunity to attack a claim. Re-examination, however, the main drawback is the slowness, because once the re-examination is granted, the patent owner can take charge of the speed with which the re-examination occurs through the office. And they can quite easily slow down the issuance of that re-examination certificate. They can petition examiner decisions. They can appeal to the Board of Appeals, onto the Federal Circuit. They can appeal those decisions as well. And so it could be many years before a resolution occurs. That is the drawback of re-examination, is that it is slow. However, it is cheap and it is effective. So please be aware that re-examination is still a strategic option for many seeking to challenge a patent claim. So in summary, I created a comparison chart of these two charts that we've covered in this talk, just comparing U.S. post-grant litigation types, comparing inter-parties review with post-grant review and re-examination, and listing who may seek these proceedings, which patents are eligible, when can the proceeding be requested, what would be the basis of that proceeding, the standard threshold for granting that review, whether or not you have to identify the real party in interest seeking the proceeding, the extent of future litigation and future prosecution estoppel that results from the proceeding, whether settlement is possible prior to a final determination of claim validity, and the overall costs of the proceedings. So for those of you that are actually in practice, this is a handy reference chart that you can use to prepare your clients for to discuss with your clients about what you could be facing in the US and the different options and the different costs. So finally, I'd like to note some practice tips for patent owners that may be facing one of these proceedings. It happens quickly. You may assert your patent for infringement and then receive a notice that an inter-parties review has been filed. Or you may have just be celebrating that your patent has been granted, only a month or two later to receive a notice to be served a post-grant review petition has been filed against your newly acquired patent. What do you do? What happens? Many times patent owners are caught unaware when they receive service that someone is seeking to review the patentability of their claims before the patent office. So I recommend to clients that they prepare prior to asserting their claims for infringement for the eventuality of both challenges in court litigation as well as challenges before the Patent Office. And that involves conducting your own validity opinion research. Have someone search your patent claims and give you render an outside opinion of the validity of those claims. And that should include an opinion on the standards of U.S. District Court litigation and the standards of U.S. administrative PTAB litigation. You should also conduct your own prosecution file wrapper forensic review. Make sure your priority claims are proper. Make sure you have named the correct inventors. Make sure that your claims are clear and definite. And consider filing a reissue application to correct any uncovered problems before you assert your patent in court and allege infringement against an infringer. Because chances are, if you assert your patent, you will be subject to an inter partes review. Consider the costs and timing. Understand the costs and the time requirements of these proceedings up front. Certainly as soon as you're noticed as a patent owner that you're facing one of these proceedings, educate yourself on how much this is going to cost and how fast it's going to move. Seek and retain experienced U.S. patent counsel quickly. You have 3 months to file that patent owner response to a petition for inter partes or post-grant review. You do not want to start looking for an attorney 2 months in. You need every day of that 3 months to prepare your response. So seek and retain your counsel quickly, if not prior to assertion, and seek counsel with prior examination experience and or prior PTAB experience, because these administrative proceedings operate very differently than court litigation. As a patent owner, your best chance for success is to convince those judges not to institute that trial. So your patent owner response is critically important to focus arguments to the procedural flaws of the petition. You want to address the status of parallel proceedings if they exist, and you want to use something called you want to argue the FinTAV factors. Now, FinTAV is a case that I did not cover in this talk because it goes deeply into the details, into the weeds, so to speak, of practice and the issue of parallel proceedings. But the PTAB will look at the status of the parallel proceeding, where it is in the district court, what's the likelihood that the district court will render a decision before they will. They will evaluate a series of factors, and they may decline to initiate an inter partes review based upon the status of other litigation. So if that is available to you as the patent owner, you absolutely have to argue that. You should attack issues and failings of the prior art. You should attack the real party in interest, whether they have been properly named or not. You should attack the petition as failing to properly construe the claim scope. You should attack the petition as time barred if that is applicable to your situation. You should attack the petition as failing to provide sufficient evidence for meeting the trial threshold. That is a way to attack the prior art. And you should save your most factual arguments for trial. Again, at the point of institution, your strongest arguments relate to the procedural flaws of the petition. If the petition is procedurally correct and the art is reasonably likely to render a claim invalid, it's going to trial. So save your heavy prior art arguments for that trial phase. If you do go to trial, exploit patent owner's expert witness advantage. The patent owner will depose the petitioner's witnesses at a time when the petitioner's witnesses are not privy to the patent owner's strategy. And at the same time, the patent owner's experts will be deposed with full knowledge of the petitioner's arguments. So that gives the patent owner an advantage to utilize their expert witnesses to frame and control the case when it comes to the technical arguments. And during trial, this is what will carry the weight and win patentability for the patent owner. You should also, if you're thrown into trial, you should consider the strategic use of disclaimers, the idea of disclaiming some but not all of the claims to reduce the damage of the trial, and you should explore settlement options. And lastly, you need to fight for the patentability of your claims. You need to avoid emotional appeals to the PTAB and keep your arguments focused on the technical aspects that distinguish your claims from the prior art. If you are a challenger seeking to institute a post-grant proceeding, again, my same recommendation: seek and retain experienced patent counsel with PTAB and examination experience. You want to create your petition utilizing the best prior art you have uncovered. You need to do an extensive search. It was fairly common when I was practicing in this space exclusively to have 4 or 5 different worldwide prior art searches conducted. We wanted to get the best prior art possible before we created our strategy for moving forward. You want to scrutinize this prior art for red flags. You want to make sure your prior art has appropriate priority date issues and does not have disclosures which teach away from what you need the prior art to do. You want to create the proposed rejection strategy in light of your petition size limits. In many instances, a petitioner will file 2, 3, or 4 or more petitions at the same time, each addressing a limited amount of issues and a limited number of claims. The patent, it does increase costs, yes, and the PTAB may, at their discretion, consolidate everything into one proceeding. But because of the page limit requirements on a petition and the word limits, you may need to create a strategy to break those petitions up into multiple petitions. Remember that your expert declarations are not subject to these page limits. So you need to exploit this aspect of the practice and fully utilize the experts to corroborate the story of the prior art that you need to tell in order to invalidate the claims. And you need to be very specific. You cannot hedge on your proposed rejections, and you cannot hedge on what that prior art teaches. You need to include in your proposed rejections, if you are proposing rejections under the concept of obviousness, you need to include in those proposed rejections the modification to the prior art, as well as the motivation that one of ordinary skill in that art would have to combine that prior art. So you actually need to write rejections the way patent examiners are supposed to write rejections. And that brings me to the end of my talk. There's so much that I did not cover here. These proceedings are so rich and interesting and complicated, and there's much more that we could have covered in this time. I hope that this lecture has given you insight into these proceedings, why they're used, why they're important, how they can be used. And I wanted to leave the remaining 20 minutes of our time together open for you guys to ask questions. So you can use the chat window and send me a question there, or I will turn control back over to our host and let him handle the question asking and translation duties. So Ben, back to you.
Okay, thank you, Jessica, for this wonderful lecture with vast knowledge. Actually, your lecture refreshed my memory of our study, time back in UNH law. At that time, those post-grant proceedings are just fresh out. So with your lecture, those several Supreme Court cases, and today I learned a lot. I mean, as you said, the rules pertaining to post-grant proceedings are getting more and more clarity. So hopefully, stakeholders can take more advantage of those post-grant proceedings and achieve their goals, achieve their business goals. So now the floor for question is open. So ladies and
Ben,
gentlemen, yep, go ahead.
While people are coming forward with their questions, I want to note something that I just realized I left out that's very important that you just reminded me of, and that is, a little bit more detail on the negotiation aspect of post-grant review.
Yeah.
I have attended licensing negotiation talks where the terms were not favorable to our client. And the other side, the patent owner, was not really wanting to negotiate or accommodate lower costs or lower licensing rates. And we had taken the liberty of preparing several inter-parties review proceedings on the patents we were negotiating a license for. And during the negotiations, this wasn't me because I was a junior attorney at the time, but the lead negotiator walked in at one of our meetings and dropped these prepared petitions on the table in front of the patent owner and basically said, we are prepared to file these today if we cannot come to resolution and agreement on the terms of this license. We will give you some time to review these petitions. And came back an hour later after giving them some time to take a look at the prepared petitions, and the entire tone and terms of negotiation changed. And so even the threat of utilizing these proceedings can be wielded as a business weapon to enhance negotiations. I just wanted to share that little story about that may be something of interest to many of the listeners on this talk. So,
Yeah, absolutely. Thank you, Jessica, for this uh, supplement. Uh, Actually, as I usually, when I made a presentation to the public, I normally present two slides, but only two sentences. One is IP is just a business game, and another is that IP is a business tool. I hope people can appreciate and understand these two quotes. So, okay, ladies and gentlemen, please take this
I
good chance.
explain that
Yep,
to my clients. I explain that, Ben, as
yep,
patents are both swords and shields.
yep,
Yeah.
absolutely.
So, questions.
Yeah, my friend. So we have friends coming in. Okay. So Gary, it's Gary. Gary, go ahead.
Okay. Uh, Thank you, Jessica, for
Mhm.
your presentation. It's very helpful. And I have a question regarding the inter-party review. So when the petitioner prepare for the IPR, and does he can use the patent document which is cited during examination by the examiner? You know, when a new patent granted on the publication, the reference cited a list. So is the patent cited or printed publication can be used again in the IPR procedure?
Yes, absolutely. It can be used again with a framing that the examiner misapprehended or overlooked a teaching. This is
Uh,
different from a re-examination where it needs to be a new question. But the same art can absolutely be used in an IPR as long as you assert and establish the examiner focused on figure 3. There's no discussion of figure 5. Figure 5 shows the invention. That's just an example of how it could be done.
so that means we need to change some point is different from the previously considered by the examiner.
You're going to need, yes, you're going to need to convince the judges that there's something to look at here, that there's a reasonable likelihood of success. You cannot just assert the exact same reasoning that the examiner asserted in the prosecution history about that art. If the art is of record but was never used in a rejection, absolutely, it's fair game in an IPR. But even if it's the exact same art that the examiner applied, perhaps they applied it under 102 and you suggested under 103. That's fine. That can support a petition.
Okay, I see. So I think it will best if we can find a new prior art, then we cooperate the new prior art into the cited reference. That will be okay, right?
Absolutely. Absolutely.
Okay, thank you.
Mhm.
Yeah, back to Gary's question. So my understanding is that so long the reasoning is not the same as the one presented before the original examiner, then the prior arts can be used, can be
Absolutely.
reused, right? Yeah.
Absolutely. It
Okay,
is
cool.
much more difficult to use cited prior art in a
Yeah.
reexamination,
Yeah.
but it absolutely flies before the PTAB judges.
Okay. So you mean
you can use the exact same art and just assert that the examiner was wrong, and have experts explain why, and the judges will buy it. Okay, it's don't think you have to come up with new prior art.
good. So you mean the threshold for re-examination is kind of higher
Yes.
regarding this
Yes.
aspect? Yeah. Okay. Cool.
Yes.
Thank you. So, more question, ladies and gentlemen? Come on, don't be shy, my friends. So maybe while our guest audience they're thinking about questions, actually, I do have some questions for you, Jessica. One is
Okay.
interesting. Yeah, I noticed that in your data, there are some cases, for the re-examination, ex parte re-examination. There are some cases initiated by the commissioner. I'm really curious. I mean, in what kind of situations would the USPTO commissioner, want to initiate a re-examination for a patent?
It's very rare. But it happens mostly when there is public outcry as to the ridiculousness of the patent. The one that I had to deal with when I was a patent examiner that was ordered by the commissioner that came through my area for review had to do with subject matter that today would have been rejected as an abstract idea. But it was before we had that jurisprudence, and an examiner didn't have prior art, so they issued the patent. And the public said, this patent is a joke. And the commissioner said, yep, it is. We're going to take another look at it. So usually they used to be called commissioner ordered reexams. They're now called director ordered reexams. Usually they are the result of a public outcry that something was egregiously missed, and on its face, it should not have been granted. They are extremely rare, but they do happen.
Okay, interesting. Thank you.
Mhm.
One other question may be relate to policy stuff. I noticed, for some cases, those appeal to the CAFC, and then the CAFC judges, kind of making some rules for PTAB more clear. But I mean, when the PTAB sets its own rules, didn't they refer those rules for comments before the courts, especially the CFC? They have
No,
no message exchanges between
there's
the
no
parties.
court influence there. Recall that the patent office is an executive agency, and the courts are part of the judicial branch of government. So there's no crossover there. The patent office's rules were subject to public comment, and public comments were submitted and were considered. But the agency created the rules that they needed to create to get these proceedings started. Now, bear in mind that rulemaking is its own procedure under administrative law in the US, and it requires public notice and the opportunity for public comment because it's the public that is impacted by the rule. And so they have to go through that process, but the process usually takes a year and a half or longer to create a rule, publish the rule, seek the comment, receive the comment, analyze the comment, amend the rule, decide whether that's the final version or whether you want additional public comment. It's usually a long process to create rules. And in this situation, the AIA passed in September of 2011 and required these trials to be started September of 2012. So the office was hit with a requirement to get a proceeding figured out, rules written, published, commented upon, analyzed, made final, and implemented in an almost unheard of time frame in the world of government rulemaking for the United States. So the public comment window was short and the rules moved forward because you can change the rules once they're written, but they were under the pressure of Congress telling them by law, you must create these proceedings in 1 year.
Gotcha. Thank you. I think we have another question. Please, Mr. Li Hao.
Yeah. Hi, Jessica. Thank you very much for the great lecture. I just have a question regarding the inter-party review, which is I wonder for the petitioner, did the petitioner was limited to only raise argument which they have already documented in their original petition, or can they raise new argument which is not raised in their petition? I think this is the first part of the question. And for the second part, I think if the answer is yes, they are only supposed to raise the argument they already mentioned in their original petition. But I think for me, I believe that the best option is to list as much combinations of the prior art as possible with all the document you have. But how do you do it in a real petition?
You're not allowed to bring new argument into a petition and into a trial based upon that petition after the trial is instituted. So you have to make all of your arguments. And you may want strategically to make many combinations of prior art. And you may have different arguments and you may have different experts with opinions about the different prior arts. And this is the solution to this dilemma in this situation is to file multiple petitions. It increases the expense, yes, for the filing, but it is the way to handle what you may need to do in that situation. You can put argument and interpretation of prior art 1 in petition 1 and argument and interpretation of prior art 2 in petition 2. And the PTAB judges will then decide if they agree with both, whether they want to combine them into one proceeding or not, but it puts the burden on the PTAB judges to make that decision. And you want that decision put on them because there is a estoppel. You are stopped from presenting the art and arguments in federal court after it's presented at the PTAB. So if the PTAB accepts some arguments and some art and not others in distinct petitions, you can try again in district court on that which the PTAB does not accept. Estoppel only applies when a trial is instituted and on the grounds instituted in that trial. So strategically, you separate these things up and you put them in distinct petitions, and you let the PTAB decide which they will allow to pass through and hear. If they don't hear it, you can go to you retain the right to go to a district court with that argument later. Does that answer your question?
Yeah, but Jessica, I think there's some detail I need to confirm with you, which is so if my understanding is correct, when the PTAB institute a procedure, and they are institute the procedure only based on specific combination of prior art, only a part of the combination which we have mentioned in the original petition, and this procedure is only based on this combination of prior art, which is already chosen by the judge, and this is how the later procedure proceeded, right?
So are you saying you got a partial institution?
I think just from your description, I have the feeling that the institution can be only based on some of the combinations which listed on the original petition, or all the institution are more likely a complete institute procedure, or they are partially instituted.
Okay, there's a distinguishment between partial and full institution of the grounds in the petition versus partial institution of the claims in the patent. And so the Supreme Court has said they cannot pick and choose the claims, but they can still pick and choose the grounds asserted against the claims. And if they do not select a ground, no estoppel applies to that ground. And that ground remains viable for a district court proceeding in the future.
Yeah. But usually,
yeah,
did that happens very
there.
often, or it happens very rare?
And what was that?
Is this partial institution happens very often, or it happens very rare?
You're getting I don't know that they track numbers on that. And if the ground there's a factual basis there, and again, the standard is more likely than not, so it's a preponderance of the evidence standard. It depends on the facts of the case and the number of claims involved and the strength of the ground. And there is a great deal of judicial discretion allowed in these proceedings. And these judges want, again, fast, speedy, just, economical. So they do not duplicate issues. They tend to not adopt grounds that are duplicative. They tend to decide what they believe are the strongest grounds. And that's why I recommend that you use the strongest, in your opinion, going in as a petitioner. You select the best prior art and the strongest arguments and positions to hold up front. If you have the space, you can include the weaker grounds and the weaker prior art in that petition and see what the judges do. If you have equally strong grounds, consider multiple petitions to give
I
each
see.
one its strongest case for the judges to accept.
Yeah, I see. Yeah, thank you very much, Jessica. I think you answered my question.
Yeah, I think Jessica, you mentioned I'd like to call it a kind of a strategy. You
Mhm.
before the PTAB, sometimes you can have several shots, to try it, and but that may be games, that can be played by those big companies, since the cost can go, very high if such strategies are executed.
Multiple petitions against the same patent are an issue and are a strategy. And those multiple petitions against the same patent and the same group of claims can come from the same petitioner or can come from different petitioners. So there can be large strategic attacks upon key patents in key portfolios by more than one person in an industry. You can share the costs, so to speak, to remove an impediment if it needs to be removed.
Yeah, right. Uh, I have one more question. Is there any leeway that one can take the advantage of both the ex parte re-examination and the PTAB proceedings? I mean, for example, let's say somebody files a ex parte re-examination, and maybe simultaneously or at a different time file a IPR petition.
In limited circumstances, yes. If they are both pending at the same time, of course, the office is going to be aware of that. And the PTAB is going to direct the examiner to stay the re-examination pending the outcome of the IPR. But it's important that a patent owner, a patent owner needs to consider filing their own re-examination based upon the art in the IPR to preserve the right to amend and add claims should they lose the IPR. So they can add narrower claims and protect something in the invention. So there could be a motivation for an examiner, for a patent owner, when thrown into an IPR, to file their own re-examination based upon that IPR's art, just so they have an application pending should all of the claims be canceled in the IPR. They can have added claims awaiting examination in the re-exam. So that's one strategy. Usually there's not an advantage to do simultaneously between the two, simply because the re-examination will be stayed. The office will not conduct those dual proceedings. However, a petitioner may consider, if time is not critical, a potential petitioner may consider filing the re-exam first and seeing what the examiner does with that art and whether the patent owner amends the claims on their own in a way that is acceptable to the business interests. And if not, because we're talking about IPR, there's no time limit. Having gone through re-examination does not preclude a future IPR on the same art if the patent owner is, does save something. So you could consider filing the re-exam first at the lower cost. And usually re-exams take about 2 years to conclusion versus the IPR being 1 year to conclusion. So your timing interest and your needs will factor into that as well as your costs. Those are the two examples that come to mind immediately about strategically why you could avail yourself to both proceedings.
Yeah, right. Exactly. Thank you. And those are, strategies could be, taken into account, for stakeholders. And by the way, I believe just now you mentioned, so did you say that there is kind of a no estoppel from, not estoppel. The question is similar to the one Gary asked at the beginning. So you mean prior arts used in the re-examination, even the reasoning is similar or even the same, those reasoning can be raised again in IPR proceedings or not?
Correct. Yes.
You can?
They could be. They could be.
So it's different from examination.
It is. It is. And see, a re-examination proceeding
Interesting.
kind of opens up the patent in a different way than a post-grant review will. And estoppel applies from post-grant review back to the office in terms of re-exams and continuations, but not the other way around. The outcomes of the re-exams, because the patent owner is in charge of that, the outcomes of the re-exam do not create estoppel to the IPR.
Okay, thank you. That's helpful. So, my friends, any more question? Let me see. I think it's already past 10. So if we have no more question coming in, then I think we may conclude for today's lecture. And again, and thank you, Jessica, for sharing with us with 2 wonderful lectures. I myself learned a lot, refreshed my memory, as I said. And I believe our audience probably has the same feeling as well. So thank you. It's a pity we are not, meet the person in person, so I can just grab before my microphone. So
Thank you,
thank you.
everyone,
Thank you,
for
Jessica.
attending my lecture. If you have future questions, feel free to reach out. And if I or my colleagues at Resolute Legal may assist you in any way with a post-grant proceeding, by all means, please contact us.
Yes, absolutely. I believe you and your colleagues would help those people in need. So everybody, here's the slide. You can see the contacts for Jessica. And should you have any question, just go directly to her and her law firm. So, oops, Jessica. Yeah, yes, keep
There it
this
is.
slide for a few seconds. So thank you, my friend, and especially thank you, Jessica. So let's keep the talks and wish you all the best.
Happy patents, everyone. Bye-bye.
Yeah, happy patents. Bye-bye.